I'm Steve Carlson, and here's the introduction to my argument to the Minnesota Supreme Court as to why Al Franken's election certificate needs to be invalidated, and he needs to be recertified to the Senate by the state of Minnesota in accordance with our contest laws, which he skipped town on as he attempted to do against Norm Coleman in 2009, just as in that petition regarding a contest called Franken versus Pawlenty. He was rebuffed by the Minnesota Supreme Court. He should be rebuffed here and slowed down so that we can examine the serious, material, and deliberate violation of Minnesota election law in that Senate race, which call into question his right to office because of the invalidity of that election. Now, a short intro to the argument. There is no indication anyone has contended that the issues I've raised are not based on the requirements of Greeley, that they be that they're serious. They're serious. And they have this case called Greenlee that says, well, anybody could just harass people with notices of contest, but nobody's said that that's what's happening. They're just saying they just want to focus on the vote count. And it's also consistent with a case called Rodebush versus Hartke, because this contest and the questions raised therein are integral to Minnesota's election machinery. And also, therefore, they're a good exercise, a valid exercise of the Minnesota legislature under Section 4 of the United States Constitution, Article 1, that talks about how you select the Congress from session to session, year to year. Nor is anybody arguing that the grounds I raised there are not core to the question of the validity of the election. We're talking about things like excluding the Independence Party from all kinds of debates, including excluding me from all the debates, the Supreme Court not doing anything to enforce any election rules unless it's like misspelling names on the ballot or whatever, which is most of that's done by the county courts anyway. And they should enforce these laws, and if they're not, this goes to the core of the question of whether the election is valid if it's the Wild West and there's ongoing violations that the courts refuse to admit is even within their responsibility. Another thing is Ritchie using voter email addresses to raise funds for his office, for his party, and to promote them, while denying the same voter email addresses to such as myself. And I was told that they did this all the time until the time I asked for it in 2012. I was told by his own employee there, and they don't deny it. They just say, so what? What if we did? I think that's core to the question of validity of the election. Then there's the question of quotas that abridge and deny the rights of white male voters and basically all voters by setting quotas for who can endorse a Democratic candidate. Now, to me, those raise serious questions about the validity of the election. And then you have a lot of people going to vote for the Democrats who don't even know that they have excluded white males from voting in the selection of their candidate through endorsement or governing their party as a whole. Because the convention where all these voting delegates go, they run the DFL party. And of course, and not only that, but that is supported by state law. It's required by state law. You can't attend or participate if you don't agree with the way the Democrats are running it. Well, I don't agree. I couldn't go there and campaign. So a lot of this is in the notice of contest, but all of it goes to the core question of the validity of the election. Now, the validity of the election is, in fact, the fundamental right which Minnesota's experienced in the 2008 election with Franken, the 2012 election with Patty McCollum, and every Minnesota election and throughout the history of democracy have shown are what were required to secure the vote and the integrity of the election. So, and the framers have endowed Minnesota with this broad grant of authority to provide a complete election code for congressional elections. Again, citing the Smiley versus Home case, a Minnesota case on congressional redistricting decided by the United States Supreme Court in 1932, and therefore really directed at the Minnesota Supreme Court. And they should get the message and follow it. And what he said, okay, broad grant of authority for all of these things. So to use the enumeration by Chief Justice Hughes of requiring protection of proper noticing in elections, registration of voters and everybody else, candidates, supervision of voting, protection of voters, prevention of fraud and corrupt practices. These are all very key to having an election. You can't just focus on the count. Because, as I said in the December 18th trial to the court, dictators tend to get a lot of votes. And Al Franken styles himself as Fidel Castro. He cannot be challenged. He's not going to be debated. He's right. He's the revolution. And he's the one who's going to go to Washington. And he'll spend all the money and he'll work with these DFL quotas and everything else, cutting out debates, just so he can get back there. I admire zeal. I admire passion. But you also have to follow the Constitution, because that is how the people of Minnesota are created. They're created because we are citizens. Otherwise, we'd be a mob. We could all go down there and holler and hoot, and who's going to go to Washington, who's going to make the rules on behalf of us, or we could follow the Constitution where we become citizens. And we follow the law. We express our views on the issues that face the country, where we can all be informed and make informed choices. This is the kind of election which I say is required, and that the legislators of Minnesota, when they acted as agents of the people in fashioning this comprehensive congressional elections code that consists of, I believe, chapters 200 to 212 of the Minnesota Code, and also other parts of it, as I think I actually get into in this argument. But as a matter of fact, I say right here, it must be assumed, contrary to the panel's idea, that the central issue in a contest for congressional elections is to ensure the votes are regularly and accurately tabulated. But it must be assumed that the legislature, in enacting this CCEC, which comprises all of the statutes 200 to 212, and also all the law which is implicated in the conduct of elections, including the public nature and availability of public information, read voter email addresses. The Minnesota Constitution is part of that, as well as those federal laws and congressional provisions which together dovetail to supplement the grant of authority under Section 4. In other words, this is the state's part in a whole federal election, which is governed by federal as well as state laws. And these are guaranteed, these protections are guaranteed to all the people of Minnesota on whom democratic rights have been conferred. And for if our lawmakers are not democratically elected, then to be bound by the laws they pass is a violation of due process, of the law of the land, and of democracy. And hence, the Constitution itself is undermined. This is a constitutional crisis, very similar to the one Archibald Cox wrote about, and when he was the special prosecutor against Richard Nixon. And one of the points he made there is that constitutionalism is in the heart. And if the people of the United States don't have it in their heart, they're not willing to enforce it, to stand up and require that it be enforced, then it's lost. Then it doesn't exist. And as I say, we lose our democratic character. We must not do this. I support the Tea Party because Tea Party people want to restore this. They want to restore this rational governance, this rational elections, and not to have people who are using the government to get enrichment for themselves, or to make themselves too big to fail, or to take over healthcare, education, and now I guess they're going to take over law enforcement. This is not the way America was intended to be. And in order to get back to where America is intended to be, we have got to follow the Constitution. And I'm asking the Minnesota Supreme Court to protect that Minnesota Constitution as it applies to congressional elections in Minnesota under the Article 1, Section 4 authority of the U.S. Constitution. And that also mandates this. All right, don't want to ramble. But the law, the question that comes up then is a threshold question, which is, can a contest be voided? That's what this appeal is about. And the certificate issued or voided or invalidated. Part of that answer is suggested in Subdivision 1, the provision Franken focused on in his 2009 effort to shut down a contest against Norm Coleman, which was triggered by automatic recount. And he wants to end it as soon as he gets ahead. Now, the law as currently written provides that, quote, in the case of a contest, the court may invalidate and revoke the certificate. Well, I guess they can. That law, unquote, that law, which does apply to the U.S. Senate, provides for a copy of the election certificate to be directly delivered to the U.S. Senate by the governor, Mark Dayton, which I guess he did on December 19th. But Subdivision 2, in addition to its own clear language, which was violated, must be read in pari materia, as part of the same material, with the entire CEEC, but here under Subdivision 1, which I just referred to. And so read, it clearly contemplates invalidation and revocation of the certificate of election in the case of a contest. And that is no doubt why Governor Dayton simply may not issue the certificate until the contest is finally determined under 209. And it was here on December 19th, 2014. Now the panel has sought to advance the legal theory, erroneously, in an abuse of discretion and ultra vires, that somehow the December 19th issuance might have been okay under the CCEC because supposedly the issuance turns solely on their determination of the vote count. This is a problem because it indicates intentionality by your panel to support the violation of a key part of contests in the CCEC and replace it with their own will, and the will of Mr. Franken and the DFL Secretary of State, not the will of the framers in 1787, the Constitution in creating Article 1, Section 4 and 5, or the people of Minnesota expressed in the formulation of the CCEC, the Comprehensive Congressional Election Code. As such, this is clearly unconstitutional behavior. And that, I guess, is just an informal introduction to my argument on this motion, that they simply must void that certificate, recertify, and in that recertification finish all the elements of the contest without further meddling, but forward a record of what has happened, plus the evidence, to the United States Senate. And then we'll go on from there. So this needs to be remanded back, and it needs to be completed. I'm Steve Carlson, and I approve this message.